Lawyers of Reddit, what's your best most badass I rest my case moment? As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Too bad those p***s already deprived him of 5 years of enjoying that check. To be fair, the check would have been a lot smaller if they hadn't tried to wait him out. His actual damages were only a few $100,000 maximum, but the bad faith insurance claim opened the door for a much higher recovery, in excess of the policy limit. So when they saw we had a fighting chance at getting that, they just gave us the entire policy limit to settle. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. I wonder how red his face got. If I was that lady, I'd have made my neck injury worse from throwing my head back in laughter. I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a complete ps examination of the issue, and his expert report was equally as ps. For those of you that don't know, expert testimony needs to meet a certain standard, the Dorbit standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dorbit motion to strike his report/testimony because the case was low value, under 100k, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend, on my own time, and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Dorbit motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate just like me do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible, but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very, very tiny area. So essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt/runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I'm aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraph 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by an hoer over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake elsewhere. However, that site was owned by a very large corporation, and I don't think the hoer wanted to fight with an entity that could fight forever. I'm guessing they were trying to discredit the expert witness. At least pick up a different book if you're trying this. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with a judge who asked the driver if he had ever sped before. No, Your Honor, I never speed, was his reply. The judge asked him a couple more times if he was sure, if he never sped. Ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding. The driver had to pay medical bills for my sister. I feel like never is not a word that should be said in the courtroom. Not to my recollection probably would have saved an additional perjury charge. It's satisfying when a bad liar gets caught. A smarter person would say that instead. So I call up my client's disgruntled former employee about a contract dispute that he started, and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a bitch. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents, and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of s. Fast forward to trial. My opposing counsel calls the lying sack of s as his first witness, and the lying sack of s acts like a lying sack of s. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract. The party suing did. After the lying sack of s left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement, where no money changes hands and no fault was admitted. We offered the deal 2 months before, and it was angrily rejected. Now, suddenly, it was accepted. Score. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the element of professional negligence. In fact, he said, "I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence." Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Did opposing counsel see it coming? That will be explored at opposing counsel's their own professional negligence. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said jokingly, "Well, of course it's fine when we ask for it. Why do you have the right to do that? We will never do that, then why do you have the right to do that? It doesn't matter, we will never do that, then why do you have the right to do that?" And so on and so forth. Transaction law is the best. This is the exact reason I'm not a fan of transactional law. Currently in a banking seat, everything is circular arguments with no determination, and you have little involvement in the actual material decisions beyond the legal stuff. That, and the admin. Dear God, the admin. My wife is a corporate lawyer at one of the Magic Circle firms here in London. She bloody loves it. I couldn't imagine anything worse. I'm a criminal barrister. I bloody love it. She can't imagine anything worse. Most of my solicitor mates are banking litigators. Assuming you mean Magic Circle, semicolon. Corporate law has a degree of allure to it for me, as it seems like it has a little less admin and at least a tad more executive function than the area I'm in at the minute. I will probably give it a try before deciding where to qualify. Never came across specifically banking litigators. I like commercial litigation in general, but sticking solely with banking lit would seem a bit dreary to me. I know of a guy at Attleshaws who does specifically financial regulation work, which I imagine has a lot of litigation involved. Personally, with respect to your career, and with all respect to you for doing it, I'm with your wife. I couldn't think of anything worse than being a criminal barrister. Different strokes for different folks. A lawyer friend of mine had written a blog post about a legal subject. Opposing counsel filed a motion again. As others pointed out, this is like the small battles which are part of the overall war of the lawsuit in which they had to cite their reasoning for their arguments. In this particular motion they chose to dig through the website of my friend, where they found that blog post which they chose to cite in their own arguments. Basically, they were going for an aha moment. You can't argue against us, because you yourself once wrote something which we think agrees with our point of view, rather than dispute the nitty-gritty details of their argument. My attorney friend simply responded with something along the lines of, "I'm honored to be cited as an expert in this area by my esteemed opposing counsel. Now, as their chosen expert, let me tell you what the law means, and why they are wrong." It was glorious. They very quickly revised their argument. I represented a company that was sued for breach of contract by a former independent contractor. Jude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Jude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Username checks out. Pretty satisfying story too. I didn't have a pink suit or a chihuahua, but I had just as much sass.